All right, so my name is Dan Brinks. I'm a professor at the University of Texas at Austin, and I'm here at the Bergen Exchanges to introduce some aspects of a project we've been working on the right to water. The right to water project has one basic question that it wants to answer, and that is essentially, what is the effect of adding the right to water to all the legal and political struggles around the access to water and sanitation? Right? So what does it do to a group's ability to advocate for themselves and for the right to water when you add this international right? And the premise that we work with and that we've been working with for a long time, most of the people who are here at the Center for Law and Social Transformation, is this one, that the effect really depends on how this new right affects the legal opportunity structure in each context. And the theory or the argument that I'm going to make today is that the elements of the legal opportunity structure and their values are mostly substitutive, right? So that one replaces the other. They don't just stack up one on top of the other to add up to more. And they're very context specific. So we'll see what that means a little bit more in a minute. And because I'm giving this presentation at the end of a very long series of sessions, I thought I would add a little bit of levity to the presentation. And so I'm presenting what I'm calling a Pokemon theory of legal opportunity structure, or a Pokemon theory of rights effectiveness. Right? So the traditional view of how rights work, of how international rights work, is that they sort of act as this universal floor below which no one can fall. Right? And that you can use this floor as a sort of trump card that you can play, right? So if you have a very weak political context in which to make your claim, in which to advocate, say, for the right to water, right? So that your political card is only worth 10 points, right? And if you have a very weak legal card to play in your domestic sphere, say you don't have the right to water in your constitution or in your legislation, right, then in comes international law with a super strong card, and you can play it as a trump card, and that's the card that's going to get you the right to water. So most of us here at the Center for Law and Social Transformation don't think that international rights work quite this way. Right? International rights, as I said at the beginning, come in and they only act to the extent that they transform the legal opportunity structure for the groups that are advocating for these rights. So that means several things. That means, for example, and first, that rights can be played in different fields. They're not necessarily these legal trump cards that you play in a legal field in the international arena. And depending on the field, they can have different values. So it may be that when you play the legal trump card, right, the legal international right, that it has a very weak effect, right, like a 10, I'm going to say, in the Pokemon card. It may be a little bit stronger as a political card. Maybe you can go into a legislature, say, or a constituent assembly, and argue that because this right has been recognized in the international arena, it should also be recognized in your constitution, or it should be reflected in your legislation somehow. Or it may be that the right doesn't work very well in either of these two contexts, but that people get very excited when you say this is a human right and it has to be protected. Right? And so it might have more of a social effect, a mobilization effect. It might bring people together and bring people out into the streets to protest. And depending on the context, depending on which social field you're in, your card, your international human right, might play a very different role, might have a very different value. So that's one thing that we know about international human rights. The other question is, what am I going to do with this right? I'm in the middle of a struggle. If I'm a group that's advocating for the right to water, say, how am I going to use this right? Well, that really depends on what other cards I have, right? So if, for example, I already have a pretty strong deck of cards that I can play, and in my context, the international human right is really actually the weakest Pokemon of them all, then it's not likely to change the terms of my struggle, the strategies I'm going to use, the arguments I'm going to use, it's probably not going to have any effect at all. If, on the other hand, it's stronger than my strongest card, whatever that card is, then I'm going to play it. Right? So whether or not this international human rights has any effect on the struggle in a particular context really depends on what's in our deck already. The other thing we know is that, well, I should back up a little bit. So for some people, right, the international rights are very weak cards to play. They think they're not really law even, really, especially something like the right to water, which is not a treaty. It doesn't have a court or a committee to enforce it, and so on. So for some people, the right is just weak across the board, and it shouldn't make any difference anywhere. For others, kind of who believe more in international human rights, it's a strong card, and so most people would want to play it. But I think what we see when we look around the world is that it's somewhere in the middle, right? In some places, the card has some value. In other places, it doesn't. And so it really depends on what we're working with already in a given context, whether we're going to play it or not, right? So, for example, in some of the countries that we're using, that we're studying in this project, we're going to see that law already gives us some really important tools. It may be that our politics are weak. It may be that we don't have the resources to mobilize. It may be that civil society isn't very well organized around this right, or doesn't have access to politicians who are responsive. But there's a legal context in which we already have very strong rights and a very strong court that's willing to enforce them. And in our cases, this is Costa Rica. Right? So Costa Rica has a constitution that has a set of rights that have been used by a constitutional court to protect lots of the same sorts of things that people argue about when they argue about the right to water. So, for example, access to clean water, protection of rivers. All of those things have been happening in Costa Rica since the 1990s, using concepts like the right to health, the right to life, the right to a clean environment. And so we have this really strong legal card we can play, and when the new international right comes in, it doesn't really change very much. It doesn't give us anything that we don't already have. It's weaker than our strongest card, and so we just don't play it. In other cases, right, where both the politics and the law are weak, then the card comes in and plays an important role. So in Brazil, for example, the Constitution of 1988 has lots of rights. It created a strong court, but it doesn't have the right to water. And the court hadn't, at least for a long time, developed any important jurisprudence around the right to water and sanitation. And so in this case, local activists have brought the right itself to the court and have asked the court to implement it, and the court has been somewhat receptive. Right? So in this case, we are playing an international right, but we're playing it in a domestic legal field rather than in an international one. Sometimes the utility of the right changes depending on where we are in the struggle, what stage, and what goals we're pursuing. So in Peru, for example, this has been very clear. Peru, in the early 1990s, had very weak legal and political tools to advocate for the right to water. The country was very much on an extractivist bent. It always has been reliant on mining. And so water rights were always secondary to extraction, to developmentalism, and so on. And so neither the political cards that people could play nor the legal ones were very strong. So when the UN declaration came in, people used it very much as a political tool. They used it in a context in which human rights has been a dominant, strong discourse because of the country's political history. They used it to advocate for a constitutional amendment that would change the domestic legal sphere. Right? So at time one, we have people using the international right to advocate for a change to the Constitution that then gives us a domestic strong legal card that we can play, and we no longer need the international right to water. Right, so in this case, we're using the international right to transform the domestic legal opportunity structure, and then once we're done, we don't need it anymore. Right, but it doesn't work for everybody. Right, so the right to water, the way it was incorporated into the Constitution, was incorporated very much as the right to drinking water, the right to potable water, and maybe sanitation, although that's not included explicitly. And for a lot of people, especially the indigenous people, this doesn't work. The indigenous people in Peru are not looking for water that comes out of a faucet. They're looking to protect the water that comes down the rivers and into their forests. They want to protect the cultural practices that are associated with those rivers. And for them, getting water out of a faucet doesn't really answer the need. And so the right, which was so strong to get a constitutional amendment passed, is very weak to get them what they want, whether it's in the political arena or in the legal arena. So really, depending on what your goals are, right, the right is going to work or not work for you. Sometimes the politics of a place also affect the value of the card. So we can't assume that a card that is worth 50 in Peru or 100 in Peru is worth 50 or 100 somewhere else. Right, so in this case, the international human right, when we're talking about the United States at the federal level, is not going to be a very strong card. The politics around human rights, especially international human rights in the United States, are such that playing an international human rights card is actually probably unhelpful, even detrimental to your case. Right, and so in this case, the international human right is the weakest card of all. And it's also very weak in the legal arena. The United States Supreme Court never recognizes international human rights as enforceable, neither do local courts. And so it's not that helpful. But when you shift to the social field, especially among young people, especially in movements that rely very much on the mobilization of university students, for example, then the international human rights card has a strong effect. People use it discursively, people use it to mobilize, people use it to organize and to draw on allies in different places, and there the card has some value. So even in the United States, you can use it in international human rights. You just can't use it in the legislature or in the courts, but you can use it in the streets and on campuses. So, to summarize, what does this mean for our theories of rights effectiveness? What is this Pokemon theory of rights effectiveness? Well, the first conclusion we can draw from that is that the utility of the right, whether it's useful to you at all, really depends on what's already in your deck. What does the legal opportunity structure and the political opportunity structure look like for you? The other thing we learned is that the value of the right really depends on local, social, and political conditions. Do you have the ability to mobilize around the right? Do you have the ability to litigate around the right? What are the politics of international human rights in your context, in your country? Those are the questions that are going to determine the value of the card and whether you can play it in your context or not. Both the utility and the value of the right depend on how well it lines up with your goals as well. Right? So if you're an indigenous person and you're trying to get a right to water that protects your rivers and streams, then this right may not be the one for you. But if you're in an urban context, in an informal settlement, and what you really need is clean water for drinking, then this might be the right water, the right for you. So again, the utility and the value of the right depends on whether it lines up with your goals. And the best use of your right really depends on which of these three fields is more receptive to international human rights discourse. Sometimes you can use it to mobilize, sometimes you can use it to litigate, and sometimes you can use it to persuade legislators or constitution writers to change the norms in your country. At the end of the day, the effectiveness of an international human right is irreducibly contextual. And how you study the effectiveness of the right really depends on where you think that card is going to be played.
Thank you.